Hello guys, this is Olayeni Dieko Daniels, popularly known as Dieko Spectre, and welcome to another episode of Dieko Talks Law. On today's episode of Dieko Talks Law, we'll be talking particularly about estate contracts in relation to purchase of land. Purchase of land in Nigeria customary law. When we are talking about the law of equity, do not forget that it is interwoven with land law, like I said in the last class. But we are talking about it in a Nigerian context. In the last class, I talked about it in the English law context, in the common law context. If you have not watched my last class, I would advise that you stop this video at this point and click the link up. There's going to be a link, showing up. Please click that link and make sure that you watch that last class before you come to this class, because this class is basically going to flow from the last class. So if you are not flowing with me, there will be a problem. There's going to be a break in transmission, which we both wouldn't like. So before we move straight into what we are talking about today, if this is your first time of coming to my channel, I want to say a very big welcome. Please make sure that you click the subscribe button and the notification bell so that anytime I release a video of this nature, you'll be one of the first set of people to watch that particular video. Also, don't forget to follow me on LinkedIn at Dieko Daniels and on Instagram at Dieko_Daniels. I would also want to make shout out to certain people who made this particular lecture possible. The first is Komolafe Praise, a University of Ilorin student who made sure that the notes were made available, and the second is Odunwole Emmanuel, a University of Lagos student who made sure that everything in relation to the media is made possible. A very big thank you to these people. So now we go straight to our lecture for today, and today we'll be talking about estate contracts. When you hear estate contracts, we are talking about purchase of land. So when you are talking about purchase of land in the Nigerian customary law context, that's basically what we are talking about today. So straight to the notes, the fact that the greater part of land in Nigeria is held not by individuals under the general English law, but by families under the customary law, has brought about a peculiar species of estate contract, that's purchase of land. Now, where land is held according to customary law, a purchaser can generally acquire a good title to it without receiving any formal conveyance as required under the English law. What we are saying is, wait. I thought we said that for you to have a good title, there has to be conveyance under our English law. That's what we learned in last class. So how are we moving away from, to get a good title, you need conveyance, it has to be in writing. If it's not in writing, then you have not a bad title, but not a good enough title. Equitable interest is not a bad title, but it's not as good as legal interest. But still, common law has been so harsh, equity has come to help. Equity has said, where you can show that there is a valid agreement, we are going to what? We are going to give you equitable interest. That is what we learned in the last class. But now we are hearing something else. We are hearing that because land in Nigeria is usually not owned by individuals as much as it is owned by family, there is another way to get a good title, even without receiving any formal conveyance as required under the English law. Now the question is, what is going on here? So let's continue with the note. According to Verity AGP, that's a judge, in the case of OGUNBAMBI versus Abowaba, what did Verity say? He said that there can be no doubt that by native law and custom, no such as written contract or conveyance are necessary to effect a valid sale. The payment of money and delivery of possession are enough. Oh, wow. I think there is something else here. Because when we are looking at the English rule, what is it telling us? For you to have equitable interest, you need to have what? An agreement. When you are looking at the English rule, for you to have a good title, that's legal interest, you must have what? A formal conveyance. But when you are coming under customary law, because writing seems to be a foreign thing to us, you can still have a good title where there are two conditions. According to what Verity has said, the judge Verity said what? There are two conditions. They have to be payment of money and delivery of possession. In the last case, where we are talking about equitable interest, there has to be only an agreement. That was the condition. There has to be an agreement. That's all. For you to have an equitable interest, there has to be an agreement. But in this case, they are saying, no, we are not saying agreement here. No be agreement with the talk. What we are saying is there has to be payment of money. Payment of money and delivery of possession. Those are the two requirements. Now, viewed from the standpoint of customary law, in such a case where A acquires a good title to land, provided, now when we are saying A acquires a good title, what we are saying is that he must have, because it's customary law, he must have gotten the necessary consent of the head of the family and all the principal members, which is why I said equity is interwoven with land law. In this case now, you need to know that for there to be a valid sale under the customary law, you must follow the principle laid down where in Ekpendu and Erika. In the case of Ekpendu and Erika, the court held that the family head and all principal member must give consent before there can be a valid sale of land. Where the family head gives consent and all but one family member does not give, the transaction is voidable to the extent of that family member, which means that if the family member then signs later, then the transaction is made okay. However, if all the family members signs but the head of the family does not sign, then the action is made void, which means that from the beginning of the whole transaction it is void. Even if the head later signs, it is void. Do you understand that? That is a principle under land law. We are talking about customary land tenure system. So you need to have a basic understanding of land law. That is what I've just explained to you now. So what we are saying is that from the standpoint, even if there have been no formal conveyancy, but the family head and the principal members have consented to the sale of land, agreed to the sale of land, A has a good title. Are you seeing that? A has what? A good title from X. That's the family. And subsequent sale by X, even if conveyed under the English law years later of the same land, will be void. Do you understand that? We are saying that family X sold land to A. Every required consent according to customary law has been followed, but there was no writing according to English law to have a legal interest. There was no writing. So even if there is no writing, so far the procedure has been followed. But don't forget that there are two elements. Verity J said not only must there have been payment, there and then consents, there must also have been what? There must have been delivery of possession, which means A must have been brought into the property. The possession must have been delivered to him. Do you understand that? The possession must have been what? Delivered to him. In the absence of the two requirements, A will not have a good title. Do you understand that? I don't think you understand. Let us look at the next rule and then we'll further explain that. Now, the principle under customary law is that if the purchaser can produce a purchase receipt evidencing the sale and show that he was let into possession of the land, he would be deemed to have acquired an equitable interest in the land analogous to an estate contract which can be converted into legal estate by decree of specific performance. Can you see that? Now, we are saying that under the customary law, what we need, two elements. Number one, purchase of land, which can be evidenced through what? Receipt. Abi? That's number one. Number two, we also need what? To be let into possession. Then it will confer upon us what? It will confer upon us the equitable interest. Although at common law, what do we need? We need an agreement. A valid agreement. The moment you have an agreement under the common law, you have an equitable interest. But agreement alone is not what we need under customary law. You need to have paid money. Are you listening? you need to have paid money. Although under the common law, you also need to have paid money, because consideration must move from the promisee. You cannot come to court and say, my lord, enforce a transaction that consideration has not moved from you. So in as much as there must have been an agreement, offer, acceptance, consideration must be present. Even though it says only an agreement, but still, to enforce it in court, you must have shown consideration. Do you understand that? He who comes to court to enforce must have shown consideration. So even though it has not been expressly stated that there must have been payment, it is implied that by you saying that there must have been an agreement, if you are to enforce it, you must have paid money. But at least there must have been a valid agreement. But under the customary law, it is clear you must have paid money. It is very clear. Very, very. Not only must you have paid, you must have been delivered possession. The person that you are buying it from, or the family that you are buying it from, must have delivered the possession to you. Those are the two requirements. When that is done, you have an equitable interest that is analogous. Analogous means that is at par, that is the same with that at common law, where they will give you a decree of specific performance to convert that equitable interest to a legal interest. Even where there is no formal conveyance, they will convert it to a legal interest. Do you understand that? And let us interrogate the case of OGUNBAMBI versus Abowaba. Now, the Oloto family in 1927 sold a plot of their land. I want you to take note of this Oloto family, because you will see how recurrent they are. The Oloto family in 1927, notice that year, in 1927, sold a plot of their family land to ex-predecessor in title. Predecessor in title means the person that came before me. So, if somebody sells a property to Mr. Kola, for example, someone sold the property to Mr. Kola, and then Mr. Kola then sold that property to me. Mr. Kola is my predecessor in title, while I am Mr. Kola's successor in title. Do you understand? Mr. Kola is the one that sold the property to me. He's therefore my predecessor in title. So if you are saying that the Oloto sold land to X's predecessor in title, that means the person that came before X, let's call that person Kola. So they sold, Oloto sold the plot of land to Kola. Kola then sold it to X. Then the Oloto family received the purchase money, for which they gave receipts to Kola, not X, to Kola, and let the purchaser into possession. So they let Kola into possession. Are you listening to me? Now, in 1948, about 10-20 years after they sold it to Kola, in 1948, the family sold and executed a formal conveyance of that same land. A formal conveyance of that same land to Y. So in your head, you'll be saying, should one is equitable, one is legal. Since it's a formal conveyance, Y is supposed to have preeminence over X. Do not forget that there is a proviso to that. Provided that Y does not know of X's interest or Kola's interest. All of them the same. You know it's Kola that he sold the land to. Is it that Y did not know that he sold the land to Kola, or since Kola has sold it to X, Y did not know that he sold the land to Kola, who has then given it to X? Do you understand that? Y contended that there was a purchase of legal estate for value without notice of X interest, which is true. Which is true, because why, when he was buying it, don't forget that they sold it 20 years ago to who? To Kola. So now, why now bought it? Not only did he even buy it, he even executed a legal conveyance, and it was like, yes, I have a solid title. I have a solid title. I am buying a land, and it's not it is legal. But do not forget, customary law is different from what? It's different from common law. Under the customary law, when you have done the two requirements, purchase of land and delivery of possession, the moment you have done it, your interest is, although equitable interest, but is so strong in common law that it is at par with what? With legal interest. Let us look at what the judge said. The judge said, the court held that X had a good title according to customary law. Can you see that? Number two, that the purchase receipt, though not admissible as proof of title because it has not been registered in accordance with section 2 of the Land Registration Act, that's the old Land Registration Act, nevertheless raised the presumption that X's predecessor in title entered into possession under an agreement for sale, which coupled with such entry was sufficient to create an equitable interest which could be converted into a legal interest or legal estate by a decree of specific performance. Number 3, that Y had constructive notice of X's interest and could not claim to be a bona fide purchaser of the legal interest without value. Do you know why they kept on putting that, there must have been delivery of possession. There must have been delivery of possession. If you are a sound student in land law and equity, you would have known. Because if you have listened to my lectures on actual imputed and constructive notice, you would know that I told you that, you see, when they said, there must have been delivery of possession, it's because they want the other party to have stayed on the land. Because the moment the other party stays on the land, any other buyer that wants to buy that property can never say that they did not have notice. And that's what the court held here. The court held that, why will you say you did not have notice? You know see X, you blind. You go land, you go buy am. You dey talk say you no get notice. You know see X. Do you understand what I'm saying? That's what the court is saying. The court is saying, why cannot say it does not have notice where X is staying on the land? Are you seeing that? That is the reason under the customary law, there must be 2 requirements. Payment. In this payment, that payment is evidenced by what? Purchase receipts. Which means that when you are reading exam question or when you are listening to a client, certain questions you are supposed to ask, although you have paid, is there any evidence of such payment? Is there a purchase receipt to show that? If there is a purchase receipt, fantabulous. Your next question: when you paid, did you get into the land? Did they deliver possession to you? Yes, they did. Wonderful. You see, those are salient and relevant questions you need to be asking according to our authority of OGUNBAMBI versus Abowaba. Because the moment both requirements are fulfilled, then we have done a good job. You have an equitable interest which would defeat any legal interest that is coming, because the equitable in itself is analogous to a legal interest which would be giving specific performance to change it to a legal interest. But then let's go to our last case for today. I told you that we have 2 cases for today, and in our next class we have 1 case. The second case for today is Olowu versus Oshinubi, while in our 3rd class, that's the part 3 of this episode, we'll be talking about Orosomi versus Idowu. But let's talk about this Olowu versus Oshinubi. What is the fact of the case? The plaintiff bought a plot of land in 1943 from the Oloto family, the same Oloto family that has issues in that previous case of OGUNBAMBI and Abowaba. In Olowu and Oshinubi, they are the same Oloto family. But what do I know? Now, the plaintiff bought a plot of land in 1943 from the Oloto family. He obtained a purchase receipt. Very good. Are you listening to that? But never obtained a conveyance. Well, if you did not, it's not really relevant. What is necessary is that what? You obtained a purchase receipt. And number 2, you were led into possession. Now, let's look at the fact. Now, in 1953, other members of the family sold and conveyed some plot of the land to the defendant. So you would know that for this particular plaintiff to be able to have such a solid interest, he has done, number 1, gotten a purchase receipt, but number 2, did he enter the land? Let us look at what the court held. The court held that the plaintiff had an equitable interest in the land, and since the defendant knows that the plaintiff was in possession, are you saying that means he entered the land, was in possession, and had been told by the plaintiff of the 1943 sale? Not only did he even see him on the land, the plaintiff even said, chairman, come, this land where you won't buy, me I don't buy am since 1943. Come see receipt. He even showed him the receipt. Not only is he in possession, he had the receipt. Now, the defendant was not a purchaser without notice, because he had notice, and so the plaintiff's equitable interest prevailed. That was very easy to find. Very, very easy. So when you are writing your exam and then people say equity is hard, I always laugh. How is equity hard? What is that about equity? Is this not the thing you are supposed to be looking at? Was there a sale? If there was a sale, is it in common law or in equity? Or is in customary law? There are 3 things you look at. If you are hearing that there is a sale of land, what are the 3 things? Number 1, is it in common law? If it's in common law, there are 2 things you look at. Was it legal through conveyance, or was it what? Equitable, through an agreement. If it's in customary law, then you also look at, was it, done by purchase receipt? These are the things. Once you understand these principles, this thing is extremely easy. But yeah, let us continue with this in my next class, where we would be discussing the part 3. Now there's an interesting requirement, another requirement that has been added. Now not only are we supposed to have a purchase receipt, no, my lords, in the other case, that's Orosomi and Indowu, said yes, purchase receipt is very important. Yes, be put on the land is very important. But then there is a third requirement that has been established in the third case. What is that third requirement? I can't wait to teach you in the next class, where we'll be talking about how to identify equitable interest, particularly purchase of land in relation to the Nigerian context, part 3. Thank you so much for watching this lecture to the end. Make sure that you like and share with your friends, and also give this video a thumbs up and all that. And also make sure that you follow me on LinkedIn at Dieko_Daniels and on Instagram at Dieko_Daniels. I will see you in my next class.